The Landesarbeitsgericht München, Munich Regional Labor Court, has made a sensational decision that has even been reported in the German press. It is a good illustration of the extent to which employees are protected in Germany. But first things first.
Welcome to YD. Why do Germans do things the way they do?
First of all, I'm not a lawyer and will stick to the article by the author Dr. Jens Usebach, LLM, here. I will also shed light on the background to some of these laws. What is it about? A student had a part-time job as a mini job in a restaurant. He started in 2018. At that time, you could earn 450 euro per month and worked until 2021. In 2025, you can earn up to 556 euro per month with a mini job tax-free. The man worked in service, and also tips in Germany are only a small amount and always voluntary. He earned around 100 euro in tips per shift. The minimum wage at that time was 84 euro per hour in 2018 and 9.50 euro per hour in 2021. So the tips was probably more than the hourly wage. Because voluntary tips are tax-free, this had been an important part of his wage. This student was a law student and had wanted a works council to be set up. Employees have the right to a works council if there are at least 5 permanent employees in the company, of whom at least 3 are eligible to vote. It is irrelevant whether these employees work full-time or part-time or as mini-jobbers, as long as they are permanently employed, or means do not only have a short-term contract. As a student had been working there since 2018, he was also permanently employed. If you're interested in a works council, you can read the Betriebsverfassungsgesetz, Works Council Constitution Act. Ask the trade union, ask a works council member perhaps from another company, or find institutions and forums that specialize in setting up and supporting works councils. There was probably an election meeting here, but it failed. If there are not enough employees for the works council and no election committee is elected, the works council will not come into being. Whether, as is sometimes reported in the press, the employer intervened against the establishment of a works council, where there is often talk of illegal methods and threats, cannot be seen in the article. However, it appears that the employer did not agree with the efforts to set up a works council, as the student was subsequently no longer included in shift planning. The student now insists on Annahmeverzug, default of acceptance. This means that an employee tells the employer that he is still employed but is not assigned any work. For example, someone who has a contract for 20 hours per week must be paid for 20 hours per week and is also available to the employer for an average of 20 hours per week. Put simply, if anyone who is not assigned work should inform the employer that they have not been scheduled and that the employer is therefore in default of accepting the employee's offer of work. This is because the employer still has to pay you even if you don't have to work because you've not been scheduled. So the student had said while he was still employed that he was not scheduled to work. He was then scheduled to work in the kitchen. There are several things to consider here. On the one hand, an employment contract typically states a specific task, for example, that you are to work as a waiter or that you are to work in the warehouse. If you are to perform a different task, you must agree to this, or the contract must be amended with an acceptance from both sides. If the store assistant does not want to work in sales, they don't have to advise customers. If I'm a waitress, I have to fetch the plates from the kitchen and place orders in the kitchen, but cooking or washing the plates is not part of my original duties, especially as there are rarely tips in the kitchen that would be worth pay. In some establishments, however, tips are collected and then shared between all employees, what means both the service and the kitchen, because everyone actually shares in the success. The student who was supposed to work in the kitchen refused. His contract presumably stated that he was to work in service, so working in the kitchen was against the contract. The employer then dismissed the student without notice, fristlose Kündigung, because he refused to work. If I, as an employee, refuse to work in accordance with a contract without an appropriate excuse, then I am in breach of the contract and can be dismissed. Termination without notice, fristlose Kündigung, means that there is no normal notice period in accordance with the German Civil Code, BGB, but that the circumstance is so bad that it is no longer possible to work together even for a short transitional period. Typical examples would be theft in the company or embezzlement of funds, in which case trust is severely damaged and termination without notice is often appropriate. But an assault or insult during work, which either originates from the employer or are not stopped despite being reported to the employer, would also severely damage the employee's trust, as would unpaid wages. So in our case, after 3 years in the restaurant, the student was initially no longer employed after he had campaigned for the establishment of a works council. Then, after his complaint, he was supposed to be employed in a place that was presumably in breach of the contract, and when he did not do this, he was dismissed without notice. The student brought an action against this and also for compensation for unpaid wages, as he had not been deployed for a long time. Also, the Amtsgericht München, Munich District Court, recognized the action for protection against dismissal. It dismissed the claims for damage in September 2022. The law student appealed. The original employer has now filed for insolvency. The employer had the legal form of a GmbH, a limited liability company. This type of company serves to separate entrepreneurial risk from private liability. In most cases, an amount of at least 20,000 euro is deposited with the GmbH, which can be used in event of liability claims, but no more than that. The owner of the GmbH is generally not liable with his personal property, like house and land. Now, it is often the case that legal disputes usually end when the company becomes insolvent because the company no longer exists. However, our student has established a transfer of business, Geschäftsübergang. This means that if, for example, another company buys a smaller company, the business remains in existence and so do the contracts. Just because a company now has a new name, because it has been bought out, does not mean that the employees' contracts are invalid in any way. If we look at Nixdorf, for example, which was taken over by Siemens in the past and traded under the name Siemens Nixdorf, then changed its name to Wincor Nixdorf and is now trading as Diebold Nixdorf after being bought out by Diebold, then some long-standing employees will still have contracts that were concluded at the time of Nixdorf, Siemens or Wincor Nixdorf and are still valid. In our case, this means that his contract would have continued to exist in the new company, and the new company would also be liable for all debts. On the 4th of June 2025, the Munich Regional Labor Court handed down its final judgment. The plaintiff was found in favor on pretty much all points. He is now entitled to a payment of around 100,000 euro in damage, a written apology, and 6-month paid holiday. This is because the company had not informed our mini-jobber about his holiday entitlement. Regardless of whether you work full-time or part-time, every employee in Germany is entitled to at least 4 weeks paid holiday in a full calendar year. Of course, the payment is different. Those who work full-time naturally receive their full-time pay during their holidays, and those who work part-time only receive their part-time pay. There are 2 videos on holiday here alone. This can of course be interesting for all those who have not yet had any holiday entitlement in their employment. If you have not been correctly informed about this, the entitlement can neither expire nor lapse. This means that anyone who has been working on a mini-job basis for 5 years and has not yet had any holiday would be entitled to at least 20 weeks of paid vacation. What makes this judgment so special is, on the one hand, the scope of the compensation, which includes not only the salary, but also the lost tips and the otherwise discounted food. It may well be that you can eat cheaper in a restaurant during your shift than the guests. In addition, overtime was often worked. This is quite interesting because the number of hours worked by mini jobbers must not exceed a certain limit, otherwise, they will exceed the earning threshold and then they are no longer tax free mini jobbers but employees subject to social security contributions who have to pay taxes and social insurance, and also the employer has to pay his share on social insurance contributions. Even the fact that the default of acceptance has already arisen due to the fact that it was not scheduled and a formal job offer from the employee was not necessary is remarkable in legal circles, as this was previously different. And then there is the apology for violation of the General Equal Treatment Act, Allgemeines Gleichbehandlungsgesetz, AGG. However, this only results from a statement in the pleadings. There, the defendant had described the plaintiff as young, 24 years old, childless, no maintenance obligations, mini-job, which the court considered to be prohibited age discrimination. All in all, the judgment showed that the court took a hard line on obstructing the Works Council even during the development phase because it clearly saw the lack of scheduling, the transfer to the kitchen, and the subsequent dismissal without notice as an attempt to intimidate the other employees as well. The amount of the damage and the compensation are remarkable. The apology for the violation of the AGG was probably also unprecedented. The personal liability of the managing director of the GmbH, who is now liable via the GmbH with private assets because he deliberately violated the Works Council Constitution Act and the periods of protection against dismissal contained therein. And the recognition of leave, because under EU law the employer must point out that leave can lapse if it is not taken on time. I hope this is a groundbreaking judgment that should deter other companies and their managers from obstructing Works Council elections and Works Council work in future, as they can now be held personally liable. And for the people who are watching here and perhaps have a part-time job as a student themselves, they should check whether their contract and the regulations in it all fit. As I always say, trade unions help you to check your own contract. You just have to go there. In the event of legal disputes about your job, they can also help with qualified lawyers, especially if you're not a law student yourself. And having a works council is a right of employees, even if there are 5 or more permanent employees. In the best case, it has nothing to do, and in the worst case, it stands up for the employee's interest. For example, that a duty rota is published in good time and then not changed without further ado. Remarks, addition, and comments in the comments. Thank you for your attention. See you in the next video.